Good morning, Mr. Kaplan.
Good morning, Your Honor. Glad to see the court. My friend here is David Chennai. May it please the court, the most important point that we are making is substantiated by documents supplied by SORB to my public records request in 2006. And that's shown at volume 1 of the appendix at pages 115 through 116. And these demonstrate that although the board had a complete membership from August 17, 2004, when Sean Jenkins was appointed, through the time of the response to the record request on June 23, 2006, that although the board was complete, that it had only one mental health professional, and that was Dr. Doreen Fay. She's a psychologist. And
let me ask you, if I could please, was there a licensed psychiatrist or psychologist on the board when your client was classified?
There was the one mental health professional, psychologist, Dr. Doreen Fay, on the board when he was classified. The board last adopted its factorial regulations in 2002, and since July of 2003, it has had only one mental health professional, and I think that that's undisputed.
Well, there's no statute that requires the board to update their regulations at certain intervals, is there?
May it please the court, we are relying largely on the court's reliance 2 years ago in one of the John Doe cases in which the individual had sought relief from the court on grounds that although he had timely applied, as we have done, for funds for an expert, and he had inquired of the hearing examiner whether the hearing examiner was qualified, that this court said that that was not necessary because the hearing examiner was applying regulations which were infused with the expertise of the board. And the court referred specifically to 178K, which required the three mental health experts. I say three because the 178K refers, separated by semicolons, to persons having certain credentials. And there are two mental health professionals, and additionally there's a mental health professional with expertise and experience with juveniles. But here we didn't have three, we didn't have two, we had one. Now, Justice Cowan says, well, is it necessary that the board update the factors? And we respond, yes it is, because in the authorities which we have cited, this court, in a case involving the personnel administrator, updating qualifications, hearing qualifications for firefighters, and the United States Supreme Court, addressing the problem of the Sentencing Commission, updating its standards, have held, yes, these agencies were appointed, they were given their qualifications, they were empowered in order that they should update their standards. And here my client is caught in a box.
Well, in those cases, or certainly in the one involving the state board, the question was if the board didn't do this, it ran the risk that the regulations at some point would no longer have a rational basis if the science got beyond the regulations and there was no attempt to keep up. I take it that's your argument here. The science may be getting beyond the regulations. So at some point, the regulations may no longer have a rational basis.
May it please the court, the board has to maintain its qualifications. It's up to the board to follow the standards. It's up to the board to remain conversant with the law. It's up to a suitably qualified board, keeping its eye on the law from time to time, to say now is the time for us to update our regulation.
So what is the time to time?
The time to time is the time that's determined by a qualified board, a board that has the
Well,
authority.
can't we infer that the board believes that it is in time yet? Because they haven't updated them?
The board has no way to make that determination one way or the other. The Superior Court judge, and I may say the Superior Court judges in Western Massachusetts, following Judge Roop, have taken the position that it matters not that the board has fallen from the required professional credentials of membership, so long as the factorial regulation, that's 1.40 and so forth, was adopted by a adequately legally qualified board.
Does the statute authorize the board to act with a vacancy on it?
This point, as a matter of fact, is addressed by the amicus brief that was filed today by the CPCS, and the answer is no. That's an interim ability for the board to act when it falls from membership, but that doesn't enable the appointing authority thereafter to once again fill up the board with persons who don't have that particular professional qualification. And we have shown that the board, in fact, did have a membership of 7 at all relevant times. The board relies on that part of 178K, which says that the board can fall down to 4 and still act, but the board did not fall down to 4. The board was reconstituted with 7, but the 7 lacked, except for Dr. Fay, lacked the required professional qualification.
So where is the prejudice to you? The factors applied to your client were in the original set of factors promulgated in 2002. Is the prejudice that maybe those factors should have been updated? Maybe there's a possibility they would change. Maybe that might affect your client. Is that your standing? Is that your prejudice?
May it please the court, my client in this particular case, at the present time, he's been out of incarceration for almost exactly 4 years. He's behaved well according to probation supervision. His therapist, Dr. Quigley, when we went into Superior Court and asked for a remand to acquire new evidence, said that he was making good progress and that, I don't remember the exact words, but the risk had been diminished, the risk of reoffense.
But didn't she also say many more months of treatment didn't she also say that many more months of treatment were necessary?
That was in the record that was made a year previous to the hearing examiner. Obviously, he needs to, she is providing further therapy. She hasn't discharged him as no longer needing it, but she did say that the risk was diminished. And recalling the difference between a level 3 and a level 2, that might make a considerable difference in the quality of life for the individual.
Mr. Kaplan, the hearing before the board in this case was in 2005, is that right?
Well,
This is an examiner hearing? Was that
I
a
think
hearing
it
officer?
was.
Yes, it was an examiner hearing. Thanks, sorry.
2006.
Well, here's my question, whether it's 5 or 6. He is entitled, I think by regulation, within 3 years after that to reapply, isn't that so?
May it please the court, that's Regulation 1.37C. He would have to show that everything that he is presenting is new. He would have to meet an enhanced standard of proof. And in addition to that, once again, he would have to go before the board, in this case the full board, looking at the matter on the record that he presented. And once again, the question arises. Now we have a board which for all of these many years, since 2003, has lacked the professional qualification that the court previously relied upon.
So what's the relief you're looking for?
May it please the court, we would take the position that the level evaluation should be annulled, that it should be treated as a tentative evaluation by the non-judicial, by the non-member board members who look at the person's record and give him a tentative evaluation, and that it should be up for evaluation, but that the matter should not proceed further until the board is reconstituted with the appropriate qualifications, and perhaps also that the board take a period of time to re-examine its regulations and determine where it's going. I noticed, for example, when this court had the Goodridge matter before it, that it gave the legislature, I believe, 180 days to do something if it was so minded. We would also take the position, if anybody would inquire of us, that the holding does not have to apply to everybody who has ever been evaluated by the board, and that the board could reasonably draw on standards, for example, by the United States Supreme Court in habeas cases where the U.S. Supreme Court says we will apply the holding to persons whose cases are pending on direct review or subject to being pending before on direct review, cases before SORB, cases during the 30-day window of opportunity to appeal, cases thereafter before the Superior Court.
But does that logically follow, though? I mean, if your position is there's no subject matter jurisdiction because the board is improperly constituted, wouldn't that have to apply to whomever had been classified throughout the period of time that the board was, as you say, improperly constituted?
A great many of these people by this time would be able to come back under 137C. If not now, then shortly.
Well, but you just said that wouldn't apply to your client, because your client would be just about ready to come back now or very shortly.
May it please the court, we would just simply rely on various precedents which indicate that as long as he is on direct review, that it isn't necessary for him to seek collateral remedies. A point I wanted to make was that the individuals who come before the board and come before the court, obviously in large measure are indigent for obvious reasons. And they're clients of CPCS, and they don't have the means to bring in experts to testify at the hearing before the hearings examiner. The attorney is disabled to accomplish a great deal for his client by bringing in learned lore because under the Reese decision, that's not appropriate. And I might also add that a decision by the appeals court, the Smith decision, that the individual is disabled to say, well, it's true that the board relied on a fragment of Hansen and Bussiere when they created their factors, but this additionally is what Hansen and Bussiere said. And the appeals court said that has nothing to do. It's up to the board to decide how much or how little or from whence a standard can be constituted addressing the learned lore. So you don't get your foot in that way. So what that means basically is that what the individual has to rely on in an unfavorable political climate is the expertise of the board. And Judge Roop said, well, the board was adequately constituted in 2002, to which we respond. The legislature, when they prescribed the qualifications, the professional qualifications of the board, intended that there should be a continuing competency, and we take the position that the appointing authorities and the board, who has to depend on the appointing authorities, have not complied with 178K and have not done what was required. I realize that my time is about to go. I should say that the standing arguments that are raised by the board are insubstantial, that because we have the direct appeal right under Section 178M, that certainly gives us standing in this case to attack the qualifications of the board. And as to the matter that was also raised about whether we've been hurt or not, we would respectfully refer the court to, I think it's a 1987 decision, Commonwealth against a Juvenile, in which the membership of the jury had been cut down from 12 to 6, and the court, I believe it was Judge Quirico, I don't recall now, said he doesn't have to definitely show that he himself was hurt by the diminution of the jury membership. It was a substantial right. He's been deprived of it. The case is reversible.
Thank you, Mr. Kelly.
Thank you, Your Honor.
Mr. Shanai?
Good morning. David Shanai for the Sex Offender Registry Board. I believe if you listen to Brother Counsel, it's his opinion that we should stop, at this point, the SORB should stop classifying sex offenders.
Mr. Shanai, let me ask you this.
Yes.
There are substantial implications for liberty in the SORB scheme. You have a board which is not in compliance with the statutory directive.
Well, you have a board that has at least 4 functioning members, and the legislature allowed that to happen. It doesn't affect...
I understand, but that's when there were not 7 members. That is to say, if there's somebody missing, sometimes there's some time lapse between when somebody's appointed. Are there 7 members of the board?
There's 7 members of the
And
board.
do those 7 members meet the statutory requirement?
Well, the board itself meets the statutory requirement because there's at least 4 sitting. The problem that you have is that the...
Of the 7 members, do they meet the statutory requirement of having the necessary professional expertise as mandated by the legislature?
Well, in this case, at the time of the classification, only 2.
The answer is no. Is that
The
right?
answer is no, in that sense that they don't meet the actual statutory
And today?
requirements. And today we have 1 individual who is a forensic psychologist.
So the answer is no.
At this point, yes.
What do we do with a board that is in blatant violation of a statutory mandate?
Well, I don't believe
You
that...
don't start off with the horror stories about what you should be doing. I mean, there are numerous professionals in this Commonwealth. The legislature made a determination. I think it made a rational determination. There's no claim that this is an irrational determination.
Well, I believe, Your Honor, that the problem is, and the board has been trying for almost a year now to fill those slots. It's hard to get trained forensic psychologists or
And let the board
psychiatrists.
go to the legislature and say this is not reasonable, and maybe the legislature will do something else. But meanwhile, you've got a legislative mandate.
I understand that, Your Honor, and the board is trying to address that, and that may be the next recourse. What they've done, at least at this point, is brought in a forensic psychologist, and they've also hired a woman who is a forensic social worker who deals especially with juveniles. It doesn't fit it
Here's my
perfectly,
concern.
but...
Well, it doesn't fit perfectly. It doesn't fit. Here's my concern. The legislature made a determination. So not only has the boards gone back and said we can't find these people, we can't persuade anybody to do it, maybe the compensation is too low, I don't know what the problems are, but they have gone ahead and filled it with unqualified people. I don't mean unqualified if there was professional qualifications. So now you're having a board make decisions. Maybe it relies on its staff, maybe it doesn't, but these are not professionals. And so they're making decisions in circumstances that don't comply with the legislative mandate.
Well, actually, they're not making decisions in that sense, because what their function is to promulgate the regulations.
I understand that, but the regulations are terribly important.
And that's the troubling part, because we generally give great deference to the expertise of administrative boards, and here's a board whose expertise is defined in statute, and yet it simply doesn't have that expertise. So should we give the same deference to Do there regulations that relate to this very technical
Well,
area?
at this time, yes, because those regulations were promulgated when the board had 3 trained psychologists on the board, and one of which had a juvenile experience
When was that?
in 2002. And those regulations are still legal, I believe, and still effective. I believe in Doe 3844, this court said that those
The
were
board has
properly
done, so the
regulated.
board has done nothing. If the board's only function, when was it, 2003?
2, I believe.
So the board has done nothing. It hasn't met, it hasn't made any decisions, it does nothing.
As to promulgating new regulations, it
Whatever
hasn't
it's-
done anything.
Whatever it's doing. You just said what the board does is issue regulations. What else does the board do?
Well, what the board does is the initial classifications are done, and then the chair of the board has the power at that point to appoint a board member or a 3-panel member or a hearing examiner to do an administrative hearing should the plaintiff request a hearing. In this case, for instance, a board member did sign off and make him a level 3 as an initial classification, and then the case
board-
went to a hearing examiner, not a board member. And then the hearing examiner applied the regulations, the regulatory risk factors to the evidence in the case. And that's how you came up with the final level 3 classification. So other than promulgating the regulations, the board itself basically does the initial classifications. Now, in this case, there was no reason why this individual needed a trained psychologist or psychiatrist to do any of the functions in his case. Right from the very beginning, he was an adult. This case involved him sexually assaulting a 6-year-old boy.
Essentially what you're saying is the legislative directive can be ignored. We don't care. It doesn't affect us. We proceed.
No, I'm not saying that. What I'm saying is that as the long...
What you're saying, it seems to me, Mr. Cheney, is for whatever reasons the legislature put that there, whatever reasons, don't know, don't care, whatever they put them there, we can proceed without complying with that. Not we're deliberately doing it, we can just proceed. And in each instance, I'll tell you, well, actually, you didn't need an expertise here. It was the chair's decision. Wasn't the board acting? They did the regulations. I mean, this may go on for 40 years, and the regulations are of 2003 regulations. Doesn't matter. This will just keep going.
Well, I hope it doesn't go for 40 years, but at the same...
You know, has there been any approach to the legislature?
At this point, my understanding is not on that issue. Again, they've been trying to fill that position or fill those positions properly. They just have been unable to do so. But more importantly, again, the regulations, the most important part when the legislature set these positions up was to have these individuals in place when they promulgated the risk factors, which have been promulgated.
You say that's the most important part. What in the legislature tells me that that's the most important part?
Well, the way it's structured and the way it goes into their roles at that point. It says nothing about a full board needing to do anything with the classification process once the rules and regulations are promulgated.
That's essentially my point, is that you said, we've decided we don't need a full board for this, so we don't have to comply with the statute.
Well, I think what you have to put into effect is that the legislature obviously thought about this issue because it not only allows the board to operate with just 4 members, but it doesn't specify that at least one of those 4 members needs to be a trained psychologist.
Again, because I think the legislature could rationally conclude that maybe an appointment couldn't be made that fast, and if the board was simply going on forever with 4 members, because you couldn't get the appropriate people, then we would have to decide whether that was sufficient. Every single case going on year after year after year after year with 4 members. But to fill them with non-professional people and say, well, we're the same as the board, which was required to have professional people, seems to me to be really quite extraordinary. And I tried very hard to think of another circumstance and haven't been able to think of another circumstance.
Well, Your Honor, again, I can't answer to that issue. I mean, I know the board is trying to rectify it, but I think we have to get back to the issue in this case is whether or not that the composition of the board has caused this individual any injury. In the board's position, it has not caused him injury that would bring him in front of this court.
Let me ask you this. Why do you have to fill the slots?
Well, we've had people resign and leave for whatever reason, mostly personal.
But if I understand your position, when the regs were enacted you had the proper makeup,
Yes, we did.
you could just go forever then, based on those regs, couldn't you?
Well, that's, right now we can, because of the fact that, again, there has been no definitive study done that would overturn the regulatory risk factors. Those risk factors are still valid today. In fact,
You haven't answered Justice Island's point, which he was stating more crisply than I perhaps have. If you can't fill the board with people who will satisfy the statutory mandate, why do you fill them with people who don't satisfy the statutory mandate?
at this point, it's designed to at least try to keep within realm. Again, we've hired a forensic psychologist and a juvenile forensic licensed social worker. That's the best we can do at this moment.
But your point was, I thought, that the primary function of the board was to promulgate the regs.
Correct.
So you don't need to have all of the expertise that is required unless you're going to promulgate some more regs, according to you.
Correct. That's the position of the board.
Mr. Chennai, could I ask you a question? Are board members compensated?
Yes, they are, Your Honor.
So taxpayer dollars are being used to pay people who do not satisfy statutory requirements. Am I correct?
I believe so.
When you mentioned that you'd hire this forensic psychologist and social worker, the social worker who specializes in juveniles, that's a staff position, not a board position?
Right now, they're board positions so that we could have at least people with that kind of experience on the board until we can satisfy the statutory requirement of finding 2 forensic psychologists or psychiatrists. We have 1 now on board, but again, it has
All right,
not
so
been
these are,
fulfilled.
when you said you hired somebody, I thought maybe you were talking about hiring a staff person with
No, I'm sorry.
expertise. You're
We've
talking about board
appointed
members.
board members.
Are these hired, I mean, are these positions appointed by the governor? I didn't.
Yes, they are.
Okay.
But you go out, I mean, but it's a hiring process.
I'm not sure the exact process how the members are selected.
It's not
I
the
believe-
board who goes out and
I
looks for
understand
them.
under these circumstances, what they did is the board advertised to get trained psychologists and forensic psychologists, and then there was a winnowing down. But these were the 2 of the candidates that applied.
Okay.
On another point, did the hearing examiner rely on this information that came about the test that the therapist had, that his therapist had administered to him? The plethysmograph test.
I was hoping I wouldn't have to pronounce it, but
Well, I tried. I butchered it for you.
the fact of the matter is the hearing examiner didn't rely on it. If you look at the summary
Well,
of decision.
he did talk about it, and he said that, I mean, his words left it unclear exactly how, the extent to which he was relying on it.
He did mention it, but again, under the regulations, CMR 1.18, Section 5, even if he looked at that, he could not accept it as evidence as to risk of reoffense, only because Ms. Quigley, who did that exam, did not appear at the hearing to testify to the results of that exam. Although he mentions it in the footnote and does mention what the defendant's response to that was, he did not actually, in his summary of decision, ever mention the fact that that test existed. And again, I think the open-endedness of that sentence in the probation report really wasn't clear enough for the hearing examiner to draw any conclusion from.
The board,
Well, he
the
did
board
not-
doesn't claim that this is scientifically valid.
No,
I mean, every single court that's looked at it has tossed it out.
correct. And we're not saying that it is scientifically valid, and that's why it had very little effect on this decision-making process. Actually, no effect on the decision-making process.
But he does say, he refers to the test to support the therapist's statement that he might need many more months of treatment.
Yes, I mean, but again, it's not involving his actual decision-making as to whether or not this individual is a level 3, a level 2, or a level 1. I think basically that footnote, he talks mostly about how the test is operated and what it's supposed to signify and what the term deviance is supposed to mean under the sex offender law at that
I
time.
mean, how can you say he talks about it? I mean, how can you say, oh, but that isn't what his decision is based on? I mean,
Well,
it's in there.
If you look at it, there's a number of footnotes on almost every issue. but they're not necessarily part of the summary of decision. I
But
think-
if it weren't necessary, then it shouldn't be in the footnote. It shouldn't be in there. And the plaintiff did not have an opportunity to contest that test in any way.
Well, first of all, the plaintiff knew ahead of time that that sentence in the probation report would be in evidence. Now, what's interesting about this case is
That that sentence was going to be in the report?
it was in a probation
evidence?
report, which was given to him as
Right, but he requested funds, and that was denied.
correct.
So what could he do?
Well, what's interesting about this case is that Ms. Quigley, who administered that test, was his ongoing therapist and wrote a letter to the board. And obviously, she could have gone to that issue. And then she also wrote a subsequent letter a year later for the Superior Court hearing. So, I mean, he had options other than expert witness fees at that point. He could have easily had her write a letter to explain it, but that wasn't done. And obviously, she was involved in the case.
Could he
How
call
can
her-
he do that? You can't just write to a professional unless there's some compensation for the professional. He may not have had to retain his expert, but if you're asking an expert to explain something, somebody has to pay that expert.
Well, she did explain many things in the letter she wrote. I guess the plaintiff never asked her to explain that piece of information. So the letter came into evidence and was weighed by the hearing examiner.
Any further questions? Thank you, Mr. Cheney.
Thank you.
Chennai.